Live, Chairman.
Good evening and welcome to this meeting of the Overview and Scrutiny Committee, meeting on Thursday the 4th of September. My name is Councillor Simon Morgan and I am the Chairperson of this committee. Members, we are streaming this meeting live as well as recorded, and by being present in the meeting, you are giving your consent to being recorded. During each item, please put your hand up to indicate if you wish to speak. I will then invite you at the appropriate time. Could I ask members to avoid approaching the top table, as this could create interference with the cameras and the live stream. Please note that the YouTube live stream sound recording is dependent on the correct use of the microphones. Therefore, can I ask that when invited to speak, you remember to turn on your microphone and turn it off when finished. Please reference a page or paragraph number when referring to the agenda papers, and keep your contributions as clear and concise as possible. We do not have any fire alarm testing scheduled for today. However, we may have periodic fire alarms, and I remind members to ensure they sign in and out when entering the council offices. If you hear the fire alarm, please exit using either the two marked fire escape routes. Once out of the building, please proceed to the designated muster point located on the grass verge by the police station entrance. So moving on to item 2, apologies for absence. Are there any apologies for absence, Committee Clerk?
No, Chairman, we haven't got any apologies tonight. I believe everyone's present.
A full house, fantastic.
Thank you.
Moving on, item 3, the minutes. It is recommended that the minutes of the meeting held on the 19th of June 2025 and found on pages 5 to 10 are approved as a true and accurate record. I so move. Do I have a seconder? Councillor Spenceley. Can we take that as agreed by consent? Thank you. Right. Moving on to item 4, declaration of interest to disclose the existence and nature of any disclosable pecuniary interests, other registrable interests and non-registrable interests relating to items of business on the agenda having regard to paragraph 9 and appendix B of the Code of Conduct for members. Members are reminded that they're also required to disclose any such interest as soon as they become aware, should the need arise through the meeting. Are there any declarations of interest? I suppose actually I should sort of put forward myself as having a non-pecuniary interest, since I am a member of the Wickham Bishops Parish Council, but we'll come more on with that as we go on. Right, moving on to item 5, public participation. We have received 2 requests from Mr. Henry Bass, who I believe is appearing on behalf of Wickham Bishops Parish Council, and Mr. Richard Kewish, who is appearing on behalf of the Wickham Bishops Action Group. Now, just to remind members and the public of the public speaking protocol, it is usual for a period of 10 minutes to be set aside at an early point of the agenda for meetings of the major committees, during which members of the public, for no more than 2 minutes each, may express views on matters of business due to be considered. It should be noted that the participants are not allowed to distribute or display papers, plans, photographs or other material, nor obviously to question or participate with just questions from officers. So, without further ado, can I invite Mr. Bass to come forward, find yourself a seat, make yourself comfortable. And you will have 2 minutes, starting from when you start to speak, Mr. Bass. Over to you.
Good evening, Mr. Chairman and members. This evening I am representing Wickham Bishops Parish Council as their Planning Committee Chairman. I made a statement at your last meeting which I have copied to the working group. I have read the working group report and I have 2 main concerns. At the last meeting I said that the application totally lacks sustainability, yet the officer cast aside all policy reasons to support of additional affordable units and recommended approval. The North West Area Committee correctly resolved to refuse, but member overturns, as we all know, are not popular with pins, so the application was damned from the start. Why was the officer's action not mentioned in the report? Were the affordable units offered or requested? What was the reasoning behind providing additional affordable housing in an unsustainable location? In the report, it mentions a perception that officers were determined to approve this application. To my mind, this is not a perception, but fact, borne out by the nature of the officer's first report and the actions taken under emergency powers to withdraw all objections and not ask for more time to consider comments, which is what the inspector requested. The suggestion that the council could be at risk of unreasonable behaviour is flawed, because no court in the land would uphold such an approach, bearing in mind the shortness of time and seasonal holidays. Bearing in mind the above, would it not be appropriate for this matter to be referred back to the working group for further considerations?
Thank you, Mr. Bass. Mr. Kirsch. Remind you again, you have 2 minutes starting from when you start to speak.
Thank you, Chairman. I represent Wickham Bishop's Action Group, who opposed the development. We recognise the outcome will not change, but lessons must be learnt and officers held accountable for decisions that range from poor to negligent and which did not represent the interests of the people they serve. The PINS letter asked if the council needed to reconsider. The correct answer was yes, and we will revisit this with members in January. That would have allowed input from key members of the North West Area Committee and met the requirements of PINS's letter. Instead, officers either panicked or deliberately sought the outcome they always wanted, approval. If deliberate, and with the greatest respect to the hard-working officers, this could appear to be gross misconduct. Otherwise, it shows very poor judgment. We dispute claims an extension couldn't be sought. PINS would understand Christmas closures, they had their own holidays, and had already delayed the appeal for months. 2 extra weeks was reasonable. The officer's full retraction of refusal reason 1 was not necessary. Even with less than 5 years housing supply, local and neighbourhood plans remain material and should have been defended under the tilted balance with arguments around sustainability, etc. By abandoning these, officers effectively guaranteed the appeal result. It is notable that the inspector stated the council members had been entitled not to accept the professional advice of officers and confirmed the scheme conflicted with local policies. This shows the refusal was reasonable and officers need not have worried about cost awards, nor should they in future. The actions of officers has damaged public trust in the council's transparency and decision making. We ask for a full explanation of officers' actions, instructions to lawyers, and whether that lawyer was a planning specialist. Legal privilege should be waived so residents can understand how their requests were undermined. Their interests undermined, sorry. Thank you.
Thank you. Thank you, Mr. Kirsch. Right, obviously both those participations lead us on to item 6, agenda item 6, which is the amended scrutiny request, which I brought forward myself, being the handling of the planning appeal at Church Road, Wickham Bishops, which members can find on pages 11 to 14. Ms. Hughes, anything you want to say to begin, just to introduce this before we move into consideration?
Yeah, so this is a report of the working group, and it's the initial assessment of the member scrutiny request. So it's now for the committee to decide and consider the report, whether the findings of the initial assessment are sufficient or whether there's any further scrutiny required, and in which case that needs to be defined so that it can be added to the scrutiny work plan. The working group also recommend an endorsement of a strengthened planning appeals protocol, which also features in the recommendations in the Woodham Mortimer scrutiny item, and that's then presented separately under agenda item number 8.
Thank you. Right, so before sort of throwing it open, I suppose really I just want to sort of sum up what I think is probably the nub of the arguments that the other participants have put, which is, and I mean, you ready to able to sort of discuss this, or?
Chairman, you've got Mr. Johnson.
Okay, fine, Mr. Johnson here, and that is, I mean, essentially I suppose the root of this is that there is a perception that when this letter appeared on the 13th of December, seeking the council's view or seeking for comments, that, I mean, as I said, I'm simply saying this is the perception, that a sort of, I don't know, panicked response then took place with a view to making sure that this response was received by the due date that is set. Mr. Johnson, can you perhaps give us your view as to exactly how that decision to proceed in that way was taken? Mr. Johnson? Hello?
Thank you, Chair.
Did you hear that, Mr. Johnson?
I did.
Yeah, okay.
Thank you. Yes, the letter from PINS was received on the 13th of December. That's the day after the published changes to the National Planning Policy Framework, which sort of effectively overnight changed the council's position in terms of its 5-year housing land supply, and also not less than by implication, the weight to be applied to those council policies that have a bearing on the delivery of housing. So that's the direct relation, and that's the position that officers found themselves in terms of how to then address the question which was, or the position put by PINS in their letter, which stated the inspector invites you to consider whether the framework 2024 has relevance to your case. So while that may of itself seem like a fairly simple sentence, it goes to the heart of how the council's local plan carries weight in terms of its housing delivery policies, in terms of its decisions. And it's based on that weight and how those policies are applied to the applications as to whether their applicability may be considered reasonable or not. So that's the position officers had to take into consideration with that letter. Now, the letter stated you should send any comments you wish to make to the appellant. The deadline for submission of your comments is within 2 weeks from the date of this letter. The council's response is tantamount to the submission or the key submission dates within any appeal process, within which those dates are under under general circumstances are immutable. Now, it says within 2 weeks, that the 2 weeks deadline for that date was the 27th of December. So therefore, officers had to prepare their response by the 24th. I mean, the report sets out the chain of events during that period. Yes, we had to move swift. Time was short, resources were short at that time of the year, and as the report sets out, there was no position within which any broader committee meeting could be arranged within which this matter could be considered. Had the local authority not made a decision within that period, the appeal would have been carried out, and our non-response, and this is in our professional view, and from experience in other cases, would have been considered unreasonable and could open the local authority to costs. So that was a clear, it wasn't a panicked position. Yes, the time was short and we had to move quick. Emergency powers had to be engaged, but that was a position that was faced with planning authorities. and it is with reasoned judgment, legally supported, and with officers' professional opinion, that the decision to not pursue reason for refusal 1, which at its core is based on was based on a positive 5-year housing land supply, and applying the weight of those policies behind housing delivery position, why it was felt that with the reduction in the 5-year housing land supply of the local planning authority, why that could not be supported.
Thank you, Mr. Johnson. You made several mentions there of legal advice. Can you give us or the committee what that legal advice entailed and who provided it?
Well, the legal advice was provided by the council's the council's planning solicitor.
The monitoring officer?
Yes.
Right. I mean, I have the greatest respect for the monitoring officer, but I would invite you to suggest that I don't think that she would consider herself to be a planning expert. What would your view on that be? Yes, go on, please do.
Yeah, so it's just a bit of clarification, Chair. So I think at the time of I requested the legal advice because of governance considerations in the circumstances. So although that was the monitoring officer, that was Mr. Quelch, who has obviously broader and more specialist knowledge of the planning system as well as the governance process of the local planning authority. So I just want to make that clear. We're not talking about Mrs. Holmes.
Thank you very much. Also, in terms of the question of the timing, in terms of the timing of the response, the parish council are concerned that there seems to be an inconsistency in that a similar letter was, or suggested from PINS, was received with regards to, I think it's the Walden House appeal, and a response was not then, it was actually then sent back to PINS on the 31st of December, after the deadline that has been imposed on this one. And therefore they wonder why that there's an inconsistency between the way the two appeals were handled. Can somebody perhaps help us out with that?
From my recollection, Chair, the other appeal referenced was received by the authority on a later date. Its 2-week period expired later than the period of the Wickham Bishops scheme. These letters did not all come on the same day. Letters came at various dates in December. Letters came through January, all on different dates. So it's not a case that they all came on the same day and then we then chose to respond to them differently. We responded within the deadline, the full deadline, as we could. With that subsequent appeal, officers, myself included, took time out of our Christmas period to be able to provide the response to that letter. Again, that was also because of the timing.
Okay. Just looking at the report, the clause 3.7 down at the bottom there, it said would have carried the risk of being held as unreasonable behaviour for which an award of costs may have arisen. I mean, this is a decision that was taken, collectively by the planning department, was it, or in whose sort of experience would have been brought to bear to come to that decision?
I believe, Chairman, I'm trying to recall from the time, but that conversation did include the solicitor at the time. We were talking about the governance conversation.
Okay.
And this was concerning would it be regarded as reasonable behaviour for the local authority to carry on as if it still had a 5-year land supply and defend the reason for refusal?
Well, possibly not, but I suspect what the Parish Council would view is it wouldn't be unreasonable to ask for a delay till after Christmas under the circumstances of the time.
Thanks, Chair. So this, in terms of requesting, as Mr. Johnson's already advised you in our general experience, the deadlines set by the planning inspectorate are set in the, that one was set in the knowledge that it would expire on the 27th of December. In our experience, they don't normally allow extensions to time.
Which you go on.
So that's not, sorry to clarify. So in respects of unreasonable behaviour in 3.7, that was unreasonable behaviour that may lead to costs. That's not about requesting additional time to consider the planning inspectorate's letter. Okay,
which you then lead on in clause 3.8. It was the view of officers that in their experience, PINS was not open to negotiations as to timescales it set. Right. Okay. Obviously, I would suppose to put it this way, you both, Mr. Johnson and in terms of your professional view and the way this was handled, would there be any way that you reckon this would be handled differently were this sort of similar situation to blow up this Christmas?
Well, the circumstances we were faced in that appeal were in most of our sort of planning experience is almost unprecedented. Normally, when an appeal is started, one is given a fairly considerable period of time within which one can prepare for that. And that involves the whole process of notification of relevant persons, that includes local residents, any other relevant persons, members, etc. There's exchange of documents with the other parties. There's a long period of time within which can prepare statements of common ground, statements of cases. It's a whole process that can be over a period of up to 3 months. What happened in December and following that decision was actually unprecedented. I myself have been planning for pushing 30 years. I've not come across anything of that nature before. But it still had to be responded. The timescales were still immutable, as in any other appeal. If we missed the deadline for submitting our statements of case, we cannot ask for additional period of time. That time is then lost. One would then have to run the risk of how the outcome of that, on having a case that one can present on appeal, could be challenged by the other side through a cost of award of cost application.
Okay, thank you. Although I suppose going forward, there is the changes to the planning protocol that have, as part of the recommendations, have come out of this, as well as the other one. Good. Well, members, I'll throw it open. I believe Councillor Spencer, you wish to...
So thank you, Chair. One of the things that I would say, and to our members of the public here as well, it was definitely an unprecedented time. In Heybridge, we had an application for 281 homes, which was granted. Members didn't even get to consider that application at committee. Because of the situation that emerged, it had been decided by officers, it had been refused by officers, and then the appeal was made. And so for that reason, it never came before members, something which we, as members, I can say honestly, deeply regret. But I do think that we have to be very careful with the employment of emergency powers, because we must remember, and I don't want to go on into it too much here, but these matters affect residents, and it is my own opinion that in the course of the last few years, the situation with our LDP and our land supply was not properly managed, which has led to a catastrophe for us as a district. And therefore I do feel that the officers in this case were probably faced with an enormously difficult situation at the time, although they were not probably, they were. But I think that we do have to be careful, because with regard to emergency powers, I understand the time of year, but I can almost guarantee that the members closest to this would have responded. And I think we do have to be very mindful going forward of the appeals protocol, even when the time frame, if something extraordinary happens again, is very short. And I can understand completely the frustrations of the residents on that matter. And I hope that what does come out of this committee and us looking at this is that we do strengthen, we do learn the lessons from that and strengthen our planning appeals protocol, and also that perhaps that officers are mindful of the importance of members wanting to be involved in this, even where that is difficult. Thank you.
Councillor Fittick.
Thank you, Chair. I mean, I agree with Councillor Spencer. It was a very difficult time, an unprecedented situation. And I suppose, from the perspective, we've got and we've had possible cases. There may have been criticism for actually putting that legal for reviews. But I think it's important.
Sorry, could you put your microphone?
Sorry. Yeah,
if you keep it on, yeah.
As I said, I can understand the problems that the officers face at that time, because it's an extremely unusual situation where a change to an MPPF happens immediately and changes your position from one of strength to weakness overnight. And I dare say there is a risk that if they hadn't responded and it was felt inappropriate to defend with respect to policy essay, that there could have been criticism against them for actually taking a proactive stance. But I suppose what this boils down to is, when it comes to this type of matter, who decides whether it's in the best interest of the council to move forward or not? Because it might well have been that members would have decided, well, yes, actually, we do want to progress with this and we are prepared to face the risk of cost. But again, I understand what officers are doing, and I don't think they necessarily acted inappropriately. I think probably there just wasn't any kind of mechanism to inform of what the right or wrong thing to do would be, and they were up against it. I mean, I saw a number of these letters, so I don't necessarily think the outcome was as positive as it could be, but I do on this occasion understand the position officers were placed in.
Anybody else? Yes, Councillor Morley.
Yeah, thank you, Chairman. I just wondered, as it was unprecedented times and so close to Christmas, would it have been possible to have deferred it a fraction or asked the question? You know, well, that's
the question was never asked.
You know, yeah.
Right. Okay. Well, members, we have a recommendation that the committee receives and considers the working group's report with a view to concluding this scrutiny item, and endorses the proposed revision and strengthening of the planning appeals protocol. And I so move. Do I have a second now? Councillor Morley. Yes, all agreed? Right, thank you very much. And thank you, Mr. Johnson, for that. Most helpful. Right, so moving on to, will I find it? The next agenda item, which is agenda item 7, which is the planning appeal at Woodham, Mortimer, to be found on pages 15 to 26. Susie, do you want to lead us into this?
Yeah, so this is the report of the working group with its findings and conclusions on the scrutiny work plan item, and the matter's been looked at across several meetings. It's now for the committee to consider this and decide whether to close the item. And as part of the outcome, the working group have endorsed again the strengthening of the planning appeals protocol, which is agenda item 8 for tonight.
Yes, thank you. So the key document to look at this obviously is Appendix A, And if I can refer members to part C of that, which is the suggested outcome steps to avoid this all happening again in the future, which are set out there. Was there anything you wanted to?
Not anything specific.
Okay. So we've got 4 proposals there. One is sort of training for members to help them become more familiar with the planning appeal process. Members to be aware and to be noted in the planning appeals protocol. Officers may be professionally conflicted and therefore cannot represent the council where an officer recommendation to approve has been overturned. This extends to all officers in the planning service, including managers who sign off the case. This is an education to me. Obviously, my background recently has been in the law, and it is a professional responsibility for lawyers, obviously, when they're representing a client, whatever their personal views are, to represent it the best way possible. Whereas this does not seem to be a requirement necessarily in terms of planning officers. Perhaps do you want to perhaps give us a bit more background on that, Mr. Wynn?
I can, yeah. So planning officers who are members of the Royal Town Planning Institute, inside their professional code of conduct, if they've given advice to the local planning authority, or if they're in the private sector, a client, they have to stand by that advice, even if it conflicts with the decision maker or their. So if their local planning authority decides to go against that, you would be putting the local planning authority in a very difficult position in an inquiry, public inquiry or hearing, if for example, in the questioning, the inspector or the other side, the appellant, asks whether is this in your professional, does the decision of the council equal your professional opinion? The officer of the council would have to give their professional opinion even if it differed from the decision maker. So because that's in the professional code of conduct that all members of the Royal Town Planning Institute sign up to, they will, I should not probably declare that I can't remember the precise wording off the top of my head, but you will argue passionately for your professional opinion, and once you have formed that opinion or once you have amended that opinion. So in respects of when this comes to planning appeals, this is why we would in those circumstances engage a third party as a local planning authority, often a planning consultant, who is happy to defend the decision of the planning authority. So that means they have to form the same, in professional view terms, they have to form the same opinion as the planning committee and defend that as their own. So that is the clarity, Chair.
Thank you. Members, any queries, questions, points they want to put? I wonder, particularly in view of the quite contentious, or has been contentious issues with the traveller site at the A414, just off the A414. Ms. Altshaw, are you able to give us, for the benefit of members and indeed those members of the public looking in, exactly where you think things stand with that site at this present time?
Yeah, there's nobody living on the site. There's one abandoned sort of mobile home at the back of the site, and there's an unauthorised fence at the moment. So we're waiting to see if another planning application comes in. But at the moment, no, there's no activity on the site as far as we know. We are monitoring the site. So,
could I just as I understand it, and perhaps you can help me out here, the situation with regards to the planning permission granted by the inspector is that it is still extant, but possibly largely unimplementable due to the previous actions of the applicants. Would that be?
Yes.
Right.
Yeah.
And am I right in, well, perhaps I won't necessarily say, but obviously the situation is therefore continually being monitored by you and your enforcement. Thank you.
Yeah, yeah.
Okay. Right. So, members, in terms of item 7, we have a recommendation that the committee receives and consider the working group's report with a view to concluding this scrutiny item, and endorses the proposed revision and strengthening of the planning appeals protocol. I so move. Do I have a seconder? Councillor Burrow-Cook. Is that agreed? Agreed. Good. So then moving on to item 8, which is the planning appeals protocol itself, which you can find on pages 27 to 34. Again, Ms. Hughes, is there anything you want to just lead us into that?
So this is following the findings of the previous 2 items. This is actually a suggested update to the Constitution. So if the committee are happy with it, the idea is that that's referred across to the Performance, Governance and Audit Committee, who have responsibility for reviewing the Constitution.
Thank you. Members, any comments or proposals or suggestions they want to make? In which case, let us move straight on to the recommendation. There's 2 of them. Little 1, the committee endorses the revised and strengthened version of the Planning Appeals Protocol. And little 2, the Planning Appeals Protocol Appendix A is adopted for inclusion in the Council Constitution and referral to PG&A for that recommendation. I so move. Do I have a seconder? Councillor Spenceley. Is that agreed? Agreed. Good. Thank you. So then moving on to item 9, which is the watching brief on planning enforcement. It could be a washing brief as well. Again, this is, well, Ms. Hughes, you want to just quickly set the scene?
Yep, so this is another report of the working group and this is a watching brief item on the scrutiny work plan, and it's been reviewed over several meetings. But given the continued resourcing difficulties which have hampered performance, the working group has considered that the issues explained in the report should be brought to the attention of the committee, and also consider possible reference or recommendation elsewhere, and a decision on what happens around the future of this watching brief item.
Thank you. Ms. Alton, is there anything you want to say or add to the report that's here at all in terms of how things are currently set up?
No, not really. We still have been unable to recruit into the vacant enforcement officer's post. We're trying to think of different ways of delivering that particular post to see if we can, well, just do it in a different way. We've already tried going out for national recruitment and been unsuccessful. We have got a contractor in now for 3 months who's very good, and what we're trying to do is get up to date with the service of all the notices. So there are quite a number of notices that need serving. So that person is working on them. So we'll bring that up to date. But there's very little we can do if we can't recruit anyone, into the vacant post. And we'll just speak to HR and see if there's anything at all that we can possibly do to try and encourage somebody to come forward when that post goes out for advert again.
Is that just because there's not many people in that particular field, or is it this particular area that's possible? It's just right. So there's nothing in particular about.
I think so, because I was talking to the team leader my team leader, and he goes to the Essex enforcement officers group, and a lot of the councils across Essex do not have a full complement of enforcement staff. It's quite a niche aspect of planning, so yeah, it is very difficult to recruit, and it takes quite a long time to train to be an enforcement officer as well.
Right. Councillor Fittick.
Thank you, Mr. Silvertoft. I mean, I understand the problems that you're facing here. I mean, recruiting is one thing. Are there sufficient agency staff that you could bring in on contract, budget allowed?
Did you get?
Well, it's all about budget, isn't it? You know, if there's the budget, yes, of course we could bring in contractors. We are managing the contractor in a different way than we've managed contractors before. Before they were given a caseload of work, it was called their own work. Now they're given a task list to do, and that seems to be a much more effective way of managing them. So yeah, of course, if we had more officers, contractors or permanent staff, of course we could get through more cases. What we're having to do is we are visiting the sites. That piece of the work is being done really quickly because I have a site visit officer and, you know, they're turning over the work within 3 days of a case being logged. It's the after bit that we're stuck in. So we've got now 30, I think it's 39, 40 cases where we have not actioned it. You know, we've got to wait for a case to finish before we can action a new case. But that's because we just don't have the capacity to do it.
Can I come back? I mean, I understand. I mean, it's good explanation, but I guess perhaps council have to make a choice. You know, there's no point giving you a budget that you can't actually fulfil the role that you've got, because all that will do is put huge pressure on yourself. So it might be worthwhile that the matter come to council, and if we, as members, which we always complain about the lack of enforcement, well, perhaps we might need to put our money where our mouth is. Thank you.
Do you want to see it?
Thank you, Chair. I just wanted to add to that that it's important in recognising or in talking about planning enforcement resources that we don't also just look at the planning enforcement team. Invariably, there is also a connection to the council's legal service, particularly if those matters then need to go to court. Or if for prosecution and actually just in general legal support. So I think that's probably it's probably a wider conversation for if council was minded to think about how it resources planning enforcement going forward. That we mustn't forget that there are supporting parts of the council that we are quite reliant on for planning enforcement. And the final thing in terms of I mean, as Mrs. Althoff-Shorland has said, we have taken we took the decision to get you know, an agency cover in, and we have kind of taken has kind of become a bit of a last resort, because that's an expensive way of, you know, more expensive way of getting a resource into the local authority. But I think if the council were minded to consider that might have to become a permanent way of resourcing planning enforcement, much like it is more or less at the moment for quite a big part of the development management team. And I think that would be the council considering things slightly differently, because we must remember that planning enforcement, although the investigation is a legal requirement, doing something about it and taking that case on for a greater level of to a conclusion is not a legal requirement of the local planning authority. And I know that will probably be heard by the public in quite dismay, that the council doesn't have to do anything about planning enforcement matters. It just must investigate those breaches. So if the council was so minded to think, well, it might actually have to resource planning enforcement with agency staff, it needs to consider and factor that matter into.
Thank you. Councillor Morley, do you have
Yeah, just to satisfy my curiosity, I just wondered how long roughly it takes to train, and do they have to get trained themselves, or is it do the council train them financially? Thank you.
Most planning, it depends who we employ. So if you employ a planner, a town planner, it probably doesn't take so long because they've already done part of their training to be a planner. If you just take somebody off the street who has the necessary investigation skills as a starting point, to become a sort of senior enforcement officer who can write enforcement memos and notices, I think it takes 3 to 5 years to do that successfully, because when you're writing an enforcement memo, what we call a memo, what you're basically doing is you're writing a planning report and you're setting out the planning principles of making that decision to take enforcement action, and you're writing your appeal statement, your ground A appeal statement, which is should the unauthorised development have planning permission. So that's why it takes so long to actually fully train an enforcement officer. And then, of course, if you want to go on to be a team leader and things, it takes even longer.
Thank you. Right, was that something? Councillor Morley, sorry. Yeah.
I was nodding agree.
Okay.
Yeah.
Thank you, Chair. So a couple of things around that, really. I've got 2 points. One is, I'm sure, and I don't know how difficult it would be, but you probably have already looked at working with other authorities. You're saying other authorities in Essex are in a similar position, but I wondered if all neighbouring ones were and whether there was any possibility of working with other authorities. I guess that's complex, thinking about the reliance on other services within the council. So for enforcement, perhaps that's really complex. But my other point really was with regard to, I think, you know, okay, so it isn't a legal requirement for us to actually act on you know, in a more substantial way on enforcement. But I think, given the situation we find ourselves in at the moment as a council, and that, let's be honest, we've got planning permissions coming forward that we never envisaged, and all kinds of things coming out of that. I mean, even well, you know, you look at some of the conditions that are being applied to make some development acceptable, for example. I think we owe it to the residents, and so therefore I do to have a service which, you know, operates as we want it to. And I think members would probably, my judgment is that members would be very keen to support that. So I think, you know, backing up what Councillor Fittick said, really, this is something that perhaps should go to council, because it has to be a priority given all the circumstances, particularly at the moment. That's my feeling on it in any case. Thank you, Chair.
Thank you. Councillor Fittick.
I just come back and I agree. I mean, we're sitting here talking about appeal problems, you know, with the Travellers site and that. And I mean, although council are always prudent with their money, I think we have to give the officers all the support and resources they need to do the job the way they want to do it. And I understand what Mr. Winslow's saying, is that sometimes you will sacrifice the non-statutory elements to make a number. Well, probably the non-statutory elements for many residents are the most important element of it. So, you know, I would certainly support a well-reasoned document coming back to council to bring you up to speed so that officers could be getting on the job that they should be doing, as opposed to, you know, trying to juggle priorities all of the time. Thank you, Chair.
Thank you. Any other comments, suggestions? Right, members, we have a recommendation the committee receives and considers the working group's report and determines whether any particular recommendations or reference needs to be made within the council to assist with the operational issues currently experienced by the planning enforcement team. And I think we should go on to that, and I would suggest we add basically a recommendation that that is indeed happens, and that we perhaps suspend the watching brief by this committee and view this as now a performance issue, and that therefore this recommendation that goes that this matter in terms of the scrutiny or the review of performance of the enforcement team moves to the Performance Government and Audit Committee. So that's two recommendations. So are you happy? You got that? If you want, or we can look at it afterwards.
Chairman, so first recommendation is to suspend the watching brief by the committee, and then to make a recommendation that the Planning, Governance and Audit Committee review performance of the enforcement team. I believe that does happen automatically as part of the performance reporting.
Okay. Yep.
I'll take advice from officers here. How would we go about moving this to full council for consideration of budget with regard to extra budget so that you can perform this role successfully, because it feels to me like all we're doing really with sending it to PG&A is reinforcing what PGA would already be doing. So we're going round and round in circles, and this doesn't seem to me to ever be. I mean, one of my first things that I dealt with in 2022 when I was elected was the watching brief for ONS on enforcement. So we do seem to be going around in a tiny little circle. So I think it is time to move things on. Could I seek officer advice on how we might make a resolution to make that happen in the way that it should? Thank you.
Councillor, do you have a?
Enforcement doesn't report into PG&A. We don't. The only place we've ever reported is actually you at Overview and Scrutiny, and that's why I was quite pleased actually when the watching brief came about, because it's I don't know, officers don't normally say this. It's quite nice to come to members and kind of talk about your performance and have members help you along with that, because it was a great help with the mapping app that you gave us. So no, we don't actually report into PG&A at all. I don't report anywhere except, as I said, Overview and Scrutiny as a watching brief.
Thank you. Ms. Hughes, we're sort of straying to the edge of my, probably all of us are sort of knowledge here, so perhaps you could help us out?
That's fine. So you as a committee could request that officers produce a report that goes back to council with support of the Overview and Scrutiny Committee. I think that would be the neatest way to deal with it.
Right. That's in which case that sounds a brilliant idea. Yep.
Can I come back, Chair? Because if enforcement doesn't go report to PGA, I thought it didn't, and then when somebody said it did, I thought I must be wrong, which is my usual position, and always thinking I'm wrong. I think I'm not really keen, given that enforcement are stretched, to make them keep reporting to PGA if they don't already, because that seems to me kind of the exact opposite of what we want to do. So I would recommend that it might be useful, given that that this committee is minded, or might be minded if members vote that way, to carry out that suggestion of officers reporting to full council, that we actually keep it as a watching brief here as well, because then we will be able to see the effects of what happens, hopefully, going forward. Because I think it's important that it's monitored somewhere. And if officers are minded that that the support they've had here has been useful, then my proposal would be that we keep the watching brief, but at the same time we act to report to full council and request extra budget as officers. If officers prepare a report to that effect.
Okay, so
yes.
Yeah, so we'll leave the first part of the recommendation as it is, and the second part of the recommendation is to ask officers to prepare a report for this to go to full council.
Sorry, Chair. Just an alternative suggestion, just given the remit of Overview and Scrutiny Committee and the remit of PGA in terms of the terms of reference in the Constitution, I would perhaps consult Ms Hughes as on the call as well, but the committee could make a recommendation to PGA committee that they add it to their performance monitoring for planning enforcement, because yes, development management is monitored by PGA committee already, and that would therefore ensure that a fuller suite of information is monitored by PGA, which reflects the planning service.
Yeah, Councillor Stevens.
Thank you, Chair. I don't know why my microphone is much shorter than everybody else's. Can you hear me? I'm terribly sorry to say that I don't really agree with that, because I think, having served on PG&A, that it'll come up once a year or something, whereas I think we can look at it all the time. I think the important thing is to get before council to see if other members agree that we want to invest in this, and despite what we're statutorily obliged to do, put some more money into it and do what I think residents would want us to do. And it seems if you send it off to another committee, they're all going to come right back to the beginning, and everyone's got to go through everything again, which is not a great use of the enforcement officer's time. I think we should keep it here and put a recommendation through council to invest some more money in it. Thank you.
Councillor Burrow-Cook. Sorry.
Yeah, I'm all for monitoring, but I think we need to be mindful that, you know, if officers spend all their time recording things all of the time, they'll get nothing done. So, I mean, I think I'd like to take advice from the officers, because I'd imagine enforcement, it's quite a slow process. So you're probably not going to see any progress made for months and months and months. So the numbers might not change for a considerable period of time. I guess it will be helpful, perhaps. And the officers know how difficult this is. I don't. I just see numbers. And to get an understanding of what they think would be for them as professionals, a really good position to be in terms of like timelines, volumes and things like that. So you can't force a measurement on someone. They've got to be able to achieve it in the first place. So perhaps that can be part of the proposal that comes forward, is that this is what we want to achieve, and this is how we'll measure it, and this is where it will be reported. Thank you, Chair.
Thank you. Ms Hughes, could you help us out here?
Yeah, so
We'll be recommending a scenario next.
It's more that we've got to think about the point of the watching brief. So the watching brief was because we were concerned there might be an issue, and then in looking at the data, you have identified an issue in terms of resource. So we're doing something with that in terms of the referral to council. But then I personally think that the terms of reference, it would sit better for follow-up monitoring than with PGA. So you could recommend that if a change is made, that PGA then continue to review enforcement as part of the performance monitoring suite. It's just my advice.
Yes, although I think we will, rather than suspend our own watching brief, I think we'll keep it, and just so if necessary we can revive it. So we've got everybody looking at it. Councillor Burrell-Cook.
Thank you, Chair. I just had kind of a bit of clarity from the officers, really, that there's kind of two issues here. One is a backlog of elements. So what is needed to get that backlog cleared in one form, and then there's an ongoing element, which is the business as usual to make that department function correctly in terms of the officer support. So I think that needs to be brought into the proposal, that there's what can be used as a fix now, and then what's needed ongoing. Thank you.
Thank you. Myself, Shawland, you were anxious to make a comment.
Yeah, you were asking how long it takes to sort of do a case. So if a case is a no breach, and we've got enough staff, it actually doesn't take very long to sort out, you know, maybe a couple of weeks tops, really. If you've got a breach of planning control, we do ask people either to put a planning application in or to resolve that breach by remedying it. Once you get into notices and things like that, you could be looking at years to resolve it, because we're in a 2-year backlog with the planning inspector at the moment, and the courts are not timetabling things very quickly. You're looking at nearly a year to get into court. So yeah, it can be a really, really slow, frustrating process. It's not quick. We do have a backlog, but it's nothing like the backlog as when I took over. So when I took over, the backlog was, I think we had nearly 900 open cases. We've got about 339 open cases now. So it's nothing like it was, but it is creeping upwards because we've got a capacity issue. So my kind of ideal is officers should really not have more than 60 cases each open. They've got over 100, and it's unmanageable when you get to that level. You just cannot manage, no matter how efficient you are, that number of cases effectively.
Thank you.
Just last, I mean, as Carl Burrell-Cook said, I mean, there are two stages: getting it back under control, and then what we need resources-wise on an ongoing basis. So I think it would be appropriate to get it under control, and if that meant 3 resources for 6 months or a year, then whatever, you know, I'm just making numbers up. And then if it's a problem recruiting people, then you really have to assume that you're going to have people from agency. It's pointless setting a budget you can't achieve, and members will just have to realise that, or shut up and say, well, we're going to let the cases build up. As simple as that. Okay.
Yeah. Councillor Lay.
Sorry. Yeah, just to sort of add on from Councillor Fittock's point, is just if that paper that comes before council can include the challenges, so that it's available to all members, so they have some idea of the challenges faced by the things that we touched on here about market pressures and the demand, the lack of actual numbers of bodies to come in and deal with the enforcement. That would be appreciated, so it gives a fully rounded picture as to why we're looking for this increase in spend. Thank you.
Thanks.
Thanks, Chair. And appreciated having the committee's view on the parameters by that. That's quite helpful. Just to make members aware as well that we will have the planning enforcement policy update going forward as well. And I think that probably picks up some of the points which Councillor Fittock was raising about the parameters of the standard of service, what will be prioritised, what won't be prioritised. That's not to say that it may not be dealt with, but with all council resources, there's a degree of means testing as to what takes a particular priority. At the moment, they are matters to do with tree preservation orders, trees in conservation areas and listed buildings, given some legal responsibilities with those. So I think that if members are minded to make that recommendation that officers bring a report to council, we can not only do that in the context of the challenges being faced and what an alternative future could look like, but that could also factor in the policy updates which we would like to bring forward. And that has been talked about for a little while. We are speaking to parishes about that at the moment too, just to try to ensure that we're taking everyone's kind of views on board before setting the new standard as to how Maldon will approach planning enforcement.
Right, so I think where we are is that we will retain the watching brief on the data collection basis as has been happening at the moment. We will ask officers to prepare a report to go to full council with regards to increasing the resources, and also a suggestion that PG&A start also to monitor the performance of the enforcement team, which should mean they've got plenty of eyes on Ms. Alsop-Shaw, so hopefully that will help you. Am I, Ms. Hughes, is that more or less where we think we are?
Yes. Yep.
Okay, so that's my recommendation. Do I have a seconder? Councillor Burrell-Cook, is that agreed? Good, excellent. Thank you very much indeed. Right, in which case, says he rapidly scrolling back through his agenda. We come to agenda item 10, which basically is sort of looking forward to member scrutiny item requests, and really just to receive and note that the following 3 new member scrutiny requests have been received, and in line with the agreed procedure will be referred to the committee's working group at its next meeting, which is end of this month, I think, isn't it? For initial assessment and report back to the committee. That's Councillor Bell's referral regarding efficiency and performance of planning services in dealing with planning applications. Is there anything you want to say on that at this stage?
I would like to say something on that.
Yes, please.
Yes,
go ahead.
please. I've had some to and froing with Mr. Winslow and Mr. Jennings on this, and I think I'm in a position where I just need to crystallise what I actually want and what I'm actually looking for. So I might have a conversation with other members about that before I kind of put something formal, because this, I mean, last night was an illustration, wasn't it? With and that's not the first time we've been taken to appeal for non-determination, although the other one I think they've backed down. But yeah, there's trouble at Mill, and it's similar, I think, in many ways to the enforcement situation. But yeah, I do intend to bring something, but I just need to crystallise that a little bit. Thank you. Mr.
Okay,
Chair.
thank you. And Councillor Fittock, the use of policy H2 in assessing housing mix and monitoring and reporting of data. So anything you want to add to that?
Not really, other than the fact that obviously we need to understand what it is we're trying to achieve in terms of our housing mix, more in terms of the, if you like, the original principle was to reshape the district in terms of its housing stock. And I think over a patch of time we seem to have managed to move away from that, and we're basically suffering increasing unaffordability at a lower quartile level. So it's really just to make sure that we understand what reporting there is, or if there isn't reporting, to ensure that there is reporting and be on one page on the matter.
Okay. And then Councillor Stevens, post-implementation review of the new leisure contract. Do you want to?
Yes, just to say I wasn't aware that in order to hold a post-implementation view it would have to come through overview and scrutiny, but I was asked to bring it this route, which is why I've done that.
Okay.
I would have thought there would be a post-implementation review after any quite significant project automatically, but apparently not, so that's why I've raised it. Thank you.
Yeah. Councillor Lay, you were also thinking of something similar, were you? Or you sort of, is that still going ahead of you?
Yeah, it's still going ahead. Remember, we had the we'd raised the issue of the communication.
Right.
Yes,
Yes.
Which is a separate.
Right.
Obviously, once we perhaps start to discuss a leisure contract, it can go multiple ways, given the passion and impact to the wider community. So this was a focus on the communication from the decision made at council to delivery, and obviously the impact after those messages went out. What happened?
Okay. Do you want to?
Yes, sorry, agreeing with Councillor Lay really that I think, and Councillor Stevens, that I think actually this is a wider piece of scrutiny and that more will come when the working group looks at this and all aspects of what happened related to the requests that have come forward, because from my perspective, and it's not a request that I've put forward, as there are other requests now, and I think this work will come out, but I do think we need to look at what happened around the time before the tender process itself, before the procurement process started, because I think there are issues there and they relate to the communication perhaps, and also now what we're seeing with regard to post-implementation.
Consideration of the other options.
Yes.
Vestigial to say.
Yes. So I think it is a wider piece of work that will hopefully gather some sort of form as we move forward at the working group. Thank you.
Okay, so moving on to item 11. Any other items of business that the chairperson of the committee decides are urgent, and you'll be pleased to know there isn't. And therefore I close this meeting at 20:37. Thank you, members, and have a good evening.